ACV 19-0832 Calhoun versus May 1st. Each side will have 20 minutes to present their argument. If you can see, we have a clock at the bottom of the screen, but you'll primarily be responsible for watching your own time. Appellant, if you want to reserve any time for a rebuttal, you're welcome to do that, but you'll have to keep track of your own time. We're recording the argument, so when you speak, please identify yourself and your client so that we can keep everything straight. The video of this argument will be on YouTube in a few days, so you can relive how well you did. We've read the briefs, we've looked at the record, we've conferenced the case, so we're familiar with the case and the argument. So when you begin the argument, just launch right in to what you want us to know and talk about. Counsel, you may begin.
Thank you, Your Honor. May it please the court, my name is Jay Calhoun, counsel for appellants, the Calhoun Law Firm, PLC, and Jay Calhoun. And with the court's permission, I would like to reserve 2 minutes for rebuttal. This is a case about equity and fairness and an attorney's right to be paid from funds generated through the attorney's services. As an equitable jurisdiction, Arizona has recognized for over 100 years, equity favors the attorney's claim to be paid from the fruits of its labor.
Counsel, because I've got an initial question. You were successful on your claim to fees as opposed to your firm. Since you've won and you are, as opposed to your firm, are not an aggrieved party, why did you personally appeal as opposed to your law firm?
I added myself to the appeal, Your Honor, just as a matter of record to say that I believe that the attorney's fees, if they're awarded under Wheeler, that they should be reversed for Jay Calhoun as well. And that's the position that I was holding.
Okay. Thank you.
Are any other questions? May I continue, Your Honor?
Please.
Thank you. So cases since Lender v. Roca, this court has reaffirmed that a charging lien attaches to the funds or other property created by the attorney's efforts, and the charging lien has priority superior to the client and all other creditors of the client, and that's stated in Raber v. Wang. I would like to show some points.
Counsel, are there any cases that don't involve a contingent fee?
Yes, that would be the Campbell case. That did not involve a contingency fee agreement. And then there's another case from Division 2, but given the date of that case, I didn't cite it based on the Supreme Court's rule that you can't cite something based on a certain time frame.
And the Campbell one, that's in your brief?
I think that's in everyone's brief. Yes, it's a memorandum decision that the Campbell Chartered versus, yes, I can get that citation to the court.
No, yeah, we can find it. That's fine.
Okay.
But would you agree there's a difference between a contingent fee and a fee that's payable and that's owed on a monthly basis?
Yeah, I believe that there's a difference in the type of fee agreement, but I don't believe that it has any basis related to a charging lien. A charging lien is not based on the type of retention agreement you have. A charging lien is awarded based on whether you earn fees and you and the party look to the fees to pay. There's a distinction between the two.
But you're not just looking to the lawsuit recovery for your fees, are you? You're looking for your fees from any source. You're not limited to a recovery.
Well, there is no any source because MidFirst liquidated the company and sold all of its assets and left with over $100,000, and that totally and effectively dissolved the company. So there is no other source. The fees that we obtained through the settlement are the only fees that exist.
But you didn't start out saying we will only be paid if we're successful. Who was paying your fee as you went along?
The client was paying my fee as we went along. And as I argued in the trial court, that the parties agreed because the client was running out of money that the settlement funds would cover, if any, balance that the client owed. And we stated to that. And that was an undisputed fact. The client didn't, in the underlying court, the client did not dispute that fact.
But you didn't specify. You didn't say there will be a lien against the recovery. You're relying on that. We said it would come out of the recovery, and so this should be treated the same as a recovery lien in the contingent fee context.
That was one argument we made. Yes, Your Honor. The second argument is Arizona does not require you to use the language that you have to have a lien. A charging lien is granted by common law, is equitable, and it doesn't attach until there are funds. So there's no way to stipulate to a charging lien in advance, and that's not how they're created in our state.
Well, but isn't it, when we talk about equities, usually that comes up in the contingent fee context where the attorney is just going to get a percentage of the award. There will be money left over for other people. In this context, you could recover 3 times the amount of the recovery if the client pays and there's only one payment that's left. It seems like there's different equities involved when it's a contingent fee and the attorney agrees, I'm not going to collect anything unless there's a successful recovery. That's, I guess, the concern I have in applying it in this context where there's no expectation that this is a limitation on what's owed, and that is a limitation in a contingent fee case.
Well, I would argue, Your Honor, that under the equitable lien, the charging lien, the court says that the parties have to then go back to the court, or the court has to determine basically on quantum merit, what the value of the attorney's fees would be. And that's part of the charging lien. The court determines the value of the fees. So yes and no, there might be a higher recovery, but the parties, which would be me and my client, we would go back to the court, or we would be in court. I would have been in court with my client, and we would have argued what was the value, but reasonable value for my services. But as the court would note, it doesn't stop an attorney from having to cover all expenses for litigation simply because a client agreed to pay hourly. Lawyers have to pay filing fees and all of the expenses attenuated with those particular lawsuits as well. So I understand your claim, but I think it's addressed in the case law that the court has to determine the value of the services. It doesn't have to just award us the full amount.
Thank you.
Are there any other questions, Your Honor? May I continue?
Please, please do.
Okay, so the 3 points that I said I will show is that the settlement funds created by appellants' efforts should be awarded to them. The trial court erred by granting summary judgment in favor of MidFirst Bank, and the trial court erred in awarding attorney's fees to MidFirst Bank. Point 1, that the settlement funds should be awarded to Calhoun Law. A charging lien in Arizona is established by common law in favor of an attorney to satisfy attorney's fees and expenses out of the funds. The charging lien attaches to the funds or other property created by the attorney's efforts, and the parties look to the fund for payment. And this court has said that the charging lien has priority superior to the client and all other creditors, and that's in Raber v. Wang. So here, MidFirst conceded that the settlement funds resulted from Calhoun Law's efforts. MidFirst conceded that Calhoun Law was not paid for those services or the expenses it incurred. And MidFirst has conceded Arizona recognizes the charging lien.
But you were paid for some of the services, right?
early on, we were paid for some of the services, but this morphed into a 4-action litigation process where we were not paid for some of those actions, 2 appellate court decisions, and we appeared in bankruptcy court on behalf of Fast Track so we could make sure that to get the parties to move towards settlement. So there were 3 or 4 actions altogether, and we were not paid for 3 of those. And the settlement agreement indicates, Your Honor, is the court there?
Yes.
Oh, I'm sorry, the clock stopped. The settlement agreement demonstrates that there were 4 actions, and it also includes a provision that the Calhoun law firm was awarded attorney fees in which we had not been paid because the settlement funds were taken from the firm after the parties agreed to settle, but before the check was dispersed. So I'm sorry, does Your Honor have any more questions?
Does it matter? Sorry, go ahead, Judge Howe.
No, go ahead, please.
Does it matter that there's nothing specified in the fee agreement? This is just in your termination agreement where it specifies that that you're to be paid from the recovery. It makes it look like it wasn't part of the. It wasn't what was contemplated in setting up a fee agreement with the client. That the agreement seems to contemplate you're going to pay us monthly for our services.
It was contemplated for 2 things, Your Honor. I knew that this case would most likely settle. And I knew that if there was any recovery and our fees hadn't been paid, that my client could not walk away from paying our fees based on the settlement funds and take the funds for themselves. So the basis of that was, and I had represented this company since 2008, and I'd seen some of the things they've done. So the concern was that we would not invest a tremendous amount of our money, which we did, to litigate 4 claims to reach this settlement. And then the client walks away without paying our attorney fees, which earned or created those funds. So that's why that language is there. I knew at the beginning that this case would most likely settle. Does that answer your question, Your Honor?
Yes.
Are there any other questions?
No, please continue.
Okay. Thank you, Your Honors. So MidFirst has also conceded that the settlement funds stem from a settlement agreement that settled 3 matters, and the agreement includes a provision, as I said earlier, about attorney's fees awarded and still unpaid to Calhoun Law. The MidFirst claim to the settlement funds are based on a 1992 Kentucky case, McGonigal v. Holmes, and a California case, Pacific West, which is about a purchase money security interest, that ignores the inconvenient truth that we're here in Arizona, and there's case law on point that unanimously holds that a lawyer has the ultimate claim to funds that result from the lawyer's efforts. The second point I'd like to make is that the trial court erred in granting summary judgment to MidFirst because Arizona authority holds that summary judgment should be granted only, and I repeat, Your Honor, we say only in matters where there are no disputes over material facts. Calhoun Law disputed MidFirst's claim that it had a secured interest in the settlement funds or that it was a secured creditor. Calhoun Law disputed MidFirst's claims to a secured interest in the settlement funds because the funds do not stem from any purported original collateral. MidFirst failed to comply with the heightened requirements under the UCC, and MidFirst relinquished its rights to collect on any loan deficiency after MidFirst, through its lawyer Larry Folks, liquidated Fast Track, causing its dissolution. And MidFirst disputed that the Fast Track v. Galco actions were commercial tort claims. But these are just a few of the disputed material facts that show summary judgment was not appropriate to MidFirst. And to prevail on a motion for summary judgment, the movement must show there's no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. But the trial court determined that there were material facts and weighed the evidence and failed to construe it in light most favorable to Calhoun Law. The third point I'd like to make, Your Honor, is that we believe the trial court erred, or we can show that the trial court erred in awarding attorney fees to MidFirst Bank. Arizona decisions hold that fees may be awarded under ARS Section 12, 34101 in a contest between competing security interests in the same collateral. And this was not a case between competing security interests or the same collateral, because a charging lien and security interests are not synonymous, and the settlement funds are not collateral because they were not pledged to Calhoun Law, and they could not have been pledged as collateral to MidFirst in January 2014, because they did not exist. Yes, Your Honor?
But if they're traceable to collateral held by MidFirst, is that, if it is in fact traceable, would you agree that they have a security interest essentially in the asset?
Yes and no. It would depend on, first, that was a disputed fact, and we asked what was the collateral it was traceable to, and that was never identified. So that would be a disputed fact, which would mean summary judgment wasn't warranted. And traceable, the money is traceable to original collateral. It would alleviate one of the issues, but it wouldn't alleviate the UCC's heightened requirement regarding naming a commercial tort action in a security agreement. Does that answer Your Honor's question?
Yes.
May I continue?
Please.
Okay, thank you. And MidFirst acknowledges in their response on page 10, paragraph 8, that a charging lien and security interest are different. So when J. Calhoun requested attorney's fees after the trial court dismissed me as a party, MidFirst objected to that request, arguing that it was not a contract dispute. Therefore, J. Calhoun was not entitled to attorney's fees. And the trial court adopted that position and denied attorney's fees to me. But when MidFirst requested attorney's fees, they did so based on a memorandum decision in their reply brief, and the court awarded them $27,500. And the court noted that it did it based on the level of litigation without explaining what that means. It awarded fees against Calhoun Law. It said to discourage those with untenable claims to leave the matter alone. And that's 12-349 language. And we believed, and we can show, and we've shown that we have a valid defense to the claims brought by MidFirst. And the trial court further determined that the issue between an attorney's lien and its priority versus a purported security interest is not unique, although the trial court based its ruling on obsolete Kentucky and California authority. And the court finally concluded that because Calhoun lost, it should bear the consequences, which is not a basis to award discretionary attorney's fees under ARS Section 12-34101. So we're asking the court to do three things. We ask the court reverse summary judgment against Calhoun Law and remand the matter back to the trial court to award summary judgment in favor of Calhoun Law, in favor of the appellant Calhoun Law. And we ask that this court reverse summary judgment for MidFirst Bank and reverse the award of attorney's fees. Because as I said at the beginning, Your Honor, this is a case about equity. A principle Calhoun Law is asking the court to apply here, as it is done for over 100 years when an attorney's efforts created the funds. This court has given that attorney priority superior to all clients. And two quotes about charging liens and their importance sum it up. In Holly v. State, this court articulated that the law must accommodate the interest of lawyers whose efforts created the funds. Calhoun Law's efforts created the funds. And quoting from this court again in Holly v. State, in which this court wrote that it drew guidance from Skorecki, you explained that the priority afforded to attorneys charging liens has the beneficial effect of providing greater access to legal services. So in concluding, our Supreme Court has determined an attorney has a charging lien on funds and other property created by her efforts, and an attorney's charging lien has priority superior to the client and all other creditors, and equity requires the reaffirmation of this 100-year-old equitable principle of an attorney's right to be compensated from the fruits of her labor. I would like to reserve the remaining time if the court has no further questions for rebuttal.
Yes. Thank you, counsel. Counsel, You may respond.
Thank you, Your Honor. May it please the court. My name is Craig Morgan. I'm with Sherman and Howard. I represent the Applee MidFirst Bank. I would be remiss if I didn't begin by saying thank you for being here, particularly given these uncertain times. I'm consistently and continually impressed by our judiciary, and this pandemic the way the judiciary has handled it has been most impressive, and us joining each other here today virtually, I think, is an example of that. The issues on appeal are, one, did the Superior Court commit error by entering summary judgment in favor of MidFirst and against Calhoun and awarding MidFirst the disputed funds? The answer is no. That's because Calhoun does not have an attorney charging lien. But even if Calhoun had one, MidFirst had a prior perfected security interest in the disputed funds. And the second issue on appeal is, did the Superior Court commit error by deciding that under ARS 12-341 and 34101, should MidFirst have been awarded attorney's fees and costs? And the answer, go ahead.
Cancel, but the Calhoun law firm created the funds in the first place, so do they have any priority over funds that they created themselves?
The answer is no, Your Honor. We're in a situation where we've got the UCC, which is a legislatively enacted body of law, okay, that says here is how you go about perfecting a security interest, okay? And here we have a security interest in the proceeds from this collateral, which includes these settlement funds from a case that involved unjust enrichment. It involved conversion. And then you've got the common law right or common law recognition here in Arizona judicially of an attorney charging lien. I'm aware of no case anywhere in Arizona, and I haven't seen one to my research, that says that even if we assume the fund was created by Calhoun, and I don't know that it was, because I don't know that the record reflects that it was. But even let's assume for purposes of today's argument that happened. There is no case law that says that that common law lien can supplant that which the legislature has specifically recognized as the proper way to get a perfected interest in property.
Can I just take a step back, though? You're saying Calhoun law did not create that lien. Without a lawsuit, presumably those funds are not available. I mean, how can you say that their work did not create this pot of money?
I'm not
saying the defendant would have just on their own agreed to pony up some money? That seems counterintuitive to the need to file a lawsuit.
I understand, Your Honor. I'm not saying that the firm didn't. I'm saying I don't know that the record reflects that it did, other than by mentioning.
What else could it possibly reflect without a lawsuit, unless you're saying that the defendant would have paid up without a lawsuit?
I'm saying that's entirely possible, yes, Your Honor. I can't say whether the defendant would have. I will concede readily that a lawsuit was filed. I will concede that at some point a settlement occurred. It appears that the settlement was drawn up, according to our record, after the Calhoun law firm was relieved of its duties as counsel. I'm simply saying that regardless of whether there was actually a fund created by the efforts of the Calhoun law firm, they don't have a charging lien. In Arizona, it requires that you have a contract. It can be verbal, it can be written, I'll concede that. But it has to create a charging lien and look to the fund itself for the payment of the attorney. Here, we don't have any agreement that intended created a charging lien on any specific fund. And the law, I happen to believe, is a little conflicting on when you can get a charging lien and how and on what. But I do think the one thing it's very clear on is that you have to have the agreement. There has to be an intention to be paid from a specific fund. And here, can
you modify the initial agreement? The initial agreement clearly wasn't a charging lien, it was a pay by the month. But if at some point they stop paying, can you not create essentially a charging lien and say, we're going to continue to provide services and we expect to be paid a percentage, or we're going to get paid out of the whatever we recover?
I believe that's a great question, and I'll try to answer as best I can, but I think it's a two-part answer. One is, outside of the context of these facts, I would tell you, yes, I think any agreement, if the parties come to a meeting of the minds, can be amended. It can be changed. Here we have one document, okay, and we have our record. Our record does not reflect any evidence that there was ever a meeting of the minds, an agreement that they meant to have a charging lien attached to any specific fund. Okay, what we've got is a document that says you're going to pay me by the hour. And there is a passing statement in that document that says that we get paid out of any recovery. But that's not a specific fund. That's not even in the same context of being paid where they're going to be paid. They looked to an hourly payment arrangement. That's the arrangement they made. I think.
Is there a reason you can't do both? You can say, I want to be paid by the hour, and if you run out of money, I expect to be paid out of the recovery. Let's say you decided that on day one, here's my contract with the client. I want you to pay hourly, but anything you don't pay must be paid, and I have a lien against the proceeds of any recovery that I'm able to obtain for you.
I think what you just said is absolutely a possibility. It's not our facts. The word lien is nowhere in the document that purports to be the agreement at issue. There's no concept of a charging lien, a lien, an interest, security of anything in that document. So I do think it's possible, Your Honor.
It says payable from recovery, though. It's in the termination notice. Doesn't that suggest you're just saying that's not enough to be a lien? We don't use the word lien when we set up a contingent fee agreement. We don't say I have a lien against the proceeds.
I can't say that one doesn't. I think it's the better practice to. That said, I do believe I concede your point in so much that the document does say that. But again, I can't stress enough that it has to look toward a specific fund. A recovery isn't a settlement. I think a recovery can mean anything. It's a very broad thing. And the problem with the charging lien case law and Calhoun's position is that it's very clear in one respect. You have to look toward a specific fund. Here, they did not look toward a specific fund. And then the question becomes, okay, what then? And in that situation, I think you look toward the law as it relates to secured interests in any property. MidFirst perfected its secured interest in this money prior to Calhoun ever knowing it was going, or ever entering an appearance, as far as I can tell from the record, or representing, in this case anyway, the debtor at issue. So from our perspective, Your Honor, notwithstanding some, I think, inconsistencies and confusion in the charging lien case law, here Calhoun does not have a prior perfected interest of any kind in this money. And in fact, the one case I've seen that does address this issue, McGonigal, I know it was interpreting Kentucky law, but it's a Ninth Circuit case and it's instructive. It said, look, there may be equities on both sides, but the secured creditor has the better interest because they were prior in time. Nothing Calhoun does here, even if they had a secured interest, can get around, or had a charging lien, can get around the reality that MidFirst has a secured interest in these proceeds.
How is a law firm ever going to get a prior a secured interest? Aren't they always out of luck if that's all we look at?
No, Your Honor, because one, the law firm could have started representing, just use our case as an example with facts that don't exist. In our case, if the Calhoun law firm had started representing this client and had an attorney charging lien, under the cases as I read them, as long as MidFirst hadn't perfected its security interest, they have that charging lien on any specific fund they get the charging lien on.
You're saying you had already perfected your security interest because
that happened here. I was answering Judge Howell's hypothetical.
But how about if the original fee agreement with Calhoun law is just a contingent fee agreement? Would you agree they at least have an equitable lien that would have priority over your perfected lien?
I can't, under just those facts, no, it would depend. It really would depend, and here's why it would depend on it. As I read the case law, one, you can have that equitable lien, but we still have to have notice somehow, even if it's a letter. even if you're writing us a letter, which is a common way that I've seen it done, and I think the cases may have mentioned some sort of, I don't know if it was a letter or not, but the cases that we talked about, at least in my briefs, in one instance, notice was key. As long as that lien existed, and as long as notice, like you would give in any situation, the UCC just happens to give notice through recording. But here, as long as notice was given prior to that other lien perfecting, I do think there would be.
So you're saying the law firm has to give notice to every potential creditor that it's representing the client on a contingent fee basis?
I think that the law at this juncture, let me put it this way, that is onerous. And that is not something that I think is practical. But I do believe that's, under our circumstances, I think that's a fair reading. I think the common law charging lien, again, we don't have one here, but assuming we did, the common law attorney charging lien cannot supplant the UCC. The legislature did not carve out this charging lien. It did not carve out an exception for this charging lien. If it wanted to, it could have. It did not. Perhaps it should have. As a practicing lawyer, I wish it would have, but it didn't. So what we're stuck with is butting the common law recognition of a charging lien against the legislature's recognition of how to perfect a secured interest in property. And I think they can coexist, but the common law cannot supplant the legislature in this instance. Did I answer your question, Your Honor?
Yes.
Thank
Sure.
you. If I didn't, I'll try. I can try. So again, I don't think there's any dispute here that MidFirst has a secured interest in the disputed funds. It sounds to me like the court's main question is, well, does a charging lien supersede an equitable charging lien supersede a UCC secured interest? Well, the good news here, there's not one. There just isn't an equitable charging lien. I think we covered it very, very well in our briefs. It does not exist. And frankly, I think there's some confusion that I, as a practitioner, and I know my colleagues could use some guidance from this court about, is when does a charging lien even attach? If it's in a contingency case, this isn't that case. We don't have a signed agreement that's required. It doesn't appear to be contingency, it's hourly. It's unclear to me whether it can even attach to settlement funds or a judgment. There's conflicting case law, published and unpublished. And as I read on
a contingent fee on the attorney not being able to be paid out of the proceeds in a contingent fee, that you're saying there's conflicting authority on that?
No, sir. No, sir. No, Your Honor. I'm saying that in a contingency case, yes. But then where the authority, I think, gets conflicting is, does there have to be a judgment? Can it come out of a settlement? I think it's conflicting. And as I read, does the law money have to pass through the hands of the law firm before it actually has the lien? These are all conflicting issues I've seen in the cases I've cited. Some, I want to be clear, not for precedent, because they're unpublished memorandum decisions, just to show what I think is the lack of clarity. But I think here in this instance, it's pretty clear. There just is not an attorney charging. So I think the court has to acknowledge that if there's going to, I understand and I sympathize with Ms. Calhoun's passionate plea to equity. But the problem is the agreement wasn't made properly, and equity can't rewrite that agreement. If she wanted a charging lien against a specific fund, she should have said so. If the parties were going to amend their relationship and their agreement to allow that, they should have done so. But what we do know is before that relationship even started, or at least the purported agreement existed, MidFirst had a secured interest in all accounts, inventory, chattel paper, general intangibles, now owned or hereafter acquired, and any and all proceeds or products thereof. They filed a lawsuit for conversion. They filed a lawsuit for unjust enrichment and other claims. It was reduced to settlement. Money came of it. MidFirst has a lien in that money. It just does. And that money belongs to MidFirst Bank.
Could you address attorney's fees under 12-341?
Yes, Your Honor, and thank you.
And did you object to Ms. Calhoun's request for fees?
In the underlying case for Superior Court? Yes, I believe that there was an objection to the fee request.
What was the objection?
I just believe the objection at the time was she shouldn't get fees. You shouldn't get fees because fees don't apply. I'm guessing, but I know there was an objection. But I also know that as the case proceeded, The court and my predecessor counsel cited the unpublished case, which cited the published case, talking about how two parties competing for security interests in something, attorney's fees is properly awarded. I think that applies here. I would say to the court that in this case, one arises out of contract, albeit two contracts to which my client's not a party to one and Calhoun's not a part of the other, the UCC security agreement, on the one hand, a security agreement, and on the other hand, a retention agreement, okay? But the case arises out of contract. And at minimum, the parties were certainly challenging the validity of their respective contracts. That goes without question. And in fact, each was saying their contract gives them a more secured interest in that disputed fund, okay? Calhoun was saying, our law firm has a more perfected interest in that money than you do, and MidFirst was saying, no, we don't. She was saying, we do because of this type of lien. MidFirst was saying, we do because of this type of lien, both of which arise out of contract. So from my perspective, Your Honor, or my client's perspective, that, given the fact that even Calhoun said, it's at the record at 101, it sought summary judgment, quote, on the grounds that it has a valid charging lien and has priority over the settlement funds. I think the court was perfectly within its right under the existing case law to award attorney's fees and costs as it did. And unfortunately, that means that because Ms. Calhoun was dismissed from the case personally, she was entitled to an award of attorney's fees. And it's MidFirst's position that that award should stand. And in fact, based on that same principle, attorney's fees and costs should be awarded to MidFirst on appeal because they've timely requested. Are there any other questions I can answer to help the court reach a just decision?
It appears not, counsel. Thank you very much.
And I will cede the rest of my time, and thank you again for doing this and being here.
Thank you. Ms. Calhoun, you have rebuttal?
Thank you, Your Honors. I'd just like to bring up a few points. First, I think we're conflating two issues. An attorney's retention agreement is separate than an equitable grant of a charging lien that arises only after a party absconds with funds, and that charging lien is granted by the court. So it isn't something one puts in a contractual fee agreement, because if you look at Langerman, he doesn't list that he has a charging lien in his alleged contingency fee agreement. The court denied Langerman attorney's fees because there was no settlement funds for Langerman to recover from, because there was a set off of the judgment. And the case that I spoke of earlier, Campbell Law Group Chartered v. I cannot say the other party's name, Jegaleski, which is a memorandum decision. There was an hourly fee agreement. And in that case, the court clearly stated that he didn't have a fee agreement because the parties didn't look to any funds for him to recover from the funds that he recovered. But our court has also stated that recovery or look to the funds does not mean it has to be written in an agreement. It could be expressed or implied as well. So I wanted to make that point. And Calhoun Law, as the court knows, did litigate the actions, and there is a notice of settlement in the underlying record in the trial court that we filed as a part of our motion for summary judgment, where it's clear that we settled the lawsuit between the parties, and we were terminated after the settlement agreement was negotiated and almost signed and before the funds arrived. I would also ask the court look at Appendix 9. It demonstrates that Calhoun Law was a party to the underlying litigations. And then there's one point that hasn't been addressed. If Calhoun Law is not entitled to the settlement funds, MidFirst has not explained why Carlos Arboledo was allowed to take $8,000 of that money for himself when he didn't represent any of the parties throughout the litigation, and they don't have an issue with him taking those funds as well. So,
Counsel, your time is up.
Thank you, Your Honor.
We appreciate both counsel's arguments today. We'll take this matter under advisement and we'll issue our decision in due course. We stand in recess. Thank you.
Thank you. Be well.